so this is going to be the checklist for renters. So the renter docs you're going to need are rental lease agreement, agency disclosure, wire fraud advisory, tenant advisory, buyer broker, rental spuds, lead-based paint disclosure, pool disclosure, mold disclosure, and then a copy of the Arizona Landlord and Tenant Act. Best practice is to set a link to the online form to ensure it's up to date. So here's the general paperwork that a landlord will request. Two of the most recent pay stubs, two most recent bank statements, a photo of driver's license, usually just front. It's recommended to take a photo with the phone, a photo of your pets, details like the type, the breed, the if it's sprayed, neutered, the status, the gender, age. If it's a cat, is the cat declawed and litter box trained? Copy of the AAR application, Arizona Association of Realtors. For each tenant 18 or older may have their own form. The first thing to send after initial contact is the tenant advisory application for occupancy. Note, rentals are competitive, so it's beneficial to have applications and other paperwork up front. So, again, required documents: residential resale, listings, new construction, vacant land sales. Additional required documents are below. Commercial sales. When you are the seller or have ownership interest, you will need these things. Okay, so residential lease agreement. This was revised August of 2024. Okay, so here's the tenant attachment. This attachment is intended to be given to the tenant prior to the submission of any offer and is not part of the residential lease agreement terms. So here it says, attention tenant, you are entering into a legal binding agreement. So, number one, read the entire agreement before you sign it. Two, review the rules and regulations, CC&Rs, and all other governing documents, especially if the property is in a homeowners association. I mean, that's a big key thing here. If you're in HOA, you need to know the CC&Rs, you need to know the bylaws, what are the rules and regulations, when to take out the trash, when, things like that. Number three, you are strongly urged to obtain renter's insurance. Number four, investigate all material important facts. Number five, if a residential lease owner's property disclosure statement is provided, carefully review that document. This information comes directly from the landlord. Investigate any blank spaces. Read and understand your rights and obligations pursuant to the Arizona Residential Landlord and Tenant Act, a copy of which can be obtained on the Department of Housing website at www.azhousing.gov. You can also obtain information about considerations when renting a property through the tenant advisory at http://www.aaronline.com. Remember, you are urged to consult with an attorney, inspectors, and experts of your choice in any area of interest or concern in the transaction. Be cautious about verbal representations, advertising claims, and information contained in a listing. Verify anything important to you. Now, here's the residential lease agreement. So, the pre-printed portion of this form has been drafted by the Arizona Association of Realtors. Any change in the pre-printed language of this form must be made in a prominent manner. No representations are made as to the legal validity, adequacy and or effects of any provision, including tax consequences thereof. If you desire legal, tax, or other professional advice, please consult your attorney, tax advisor, or professional consultant. Landlord, here's the property owner. You'd put the landlord, put the property owner. Line 2, tenant puts their name. Line 3, landlord and tenant enter into this residential lease agreement on the terms contained herein. Landlord rents to tenant and tenants rents from landlord and the real property and all fixtures and improvements thereon and appurtenances incident thereto, plus personal property described below. Collectively, the premises. So premises address. So you'd put the address of where you're residing here. The city, the Arizona zip code. Personal property included and to be maintained in operational condition by the landlord. So here is where you would list any personal property that's included and to be maintained in operation condition by the landlord. And you get the washer, dryer, refrigerator, range oven, dishwasher, microwave, other. Occupancy. The premises shall be used only for residential purposes and only by the following named persons. Assignment and occupancy restrictions. Only persons listed above may occupy the premises or any part thereof without the landlord's prior written consent. If tenant attempts to sublet, transfer, or assign this lease agreement and or shows any persons other than those listed above to occupy the premises without the landlord's prior written consent, such act shall be deemed a material non-compliance by tenant of this lease agreement, and the landlord may terminate the lease agreement. So this just says that as the tenant, you have to put down who's going to be living there, and if there's someone else that's living there, it could lead to termination. Agenda Incorporated, lead-based paint disclosure, right? If it's built before 1978. Seller compensation, other. Term, this lease agreement shall begin on this date and end on this date. So, whenever you have a lease, you want to put the beginning and end date. At which time this lease agreement shall automatically continue on a month-to-month basis with all other terms and conditions set forth herein remaining the name, unless the party provides written notice to the other of their intention to terminate the lease agreement. Notice to terminate the lease agreement at the end of the original term shall be given on or prior to the last rental due date of the original term. Notice to terminate, if on a month-to-month basis, shall be given 30 days prior to the periodic rental due date. At lease termination, tenant shall return the keys, all keys, garage door, entry gate openers as described herein, and vacate the premises. If tenant willfully fails to vacate the premises as provided for in this lease agreement, landlord shall be entitled to recover an amount equal to but not more than 2 months periodic rent, or twice the actual damages sustained by landlord, whichever is greater, as provided for in the Arizona Residential Landlord Tenant Act. So it just says if you don't vacate by the time, then you'll owe twice the rent. Earnest money, you can put down if you are going to put earnest money, released from all obligations under this lease agreement by notice to the tenant upon acceptance of this lease agreement by all parties. All earnest money shall be applied to deposits and or initial rents. Line 41, periodic rental due date. The rent and all other accrued changes shall be due and payable no later than 5 p.m. on the blank day of each month, regardless of weekends or holidays. Rent Rent shall be payable in advance without deductions or offsets. Landlord is not required to accept a partial payment of rent or other charges. If the sales tax changes during the term of this lease agreement, the landlord may adjust the amount of rent due to equal the difference caused by the tax change upon 30 days notice to tenant. So the rent, here's the tenant shall pay monthly installments of this amount of money plus any applicable sales tax, which are currently this amount of money totaling this. Late charges and returned payments. A late charge of blank shall be added to all rent not received by blank 5 p.m. on the due date or blank days after due date and shall be collectible as rent. A tenant shall pay a charge of blank money for all funds dishonored for any reason in addition to the late charge provided herein. These additional charges shall be collectible as rent. If a rent payment has been returned unpaid for any reason, landlord shall be entitled to demand that all sums due pursuant to this lease agreement be paid in the form of a cashier's check or money order. Late or partial payments. The acceptance by landlord of any late or partial payment shall not change the due date or amount of any required payment in the future and shall not relieve tenant of any obligation to pay the balance of the rent and any applicable late fees or costs. Rent proration. If the rent is being prorated for a period other than a full month, tenant shall pay on, you put the date there and the money plus any applicable sales tax. Note the ARLTA or ALTA prohibits a landlord from demanding or receiving security. However, denominated including but not limited to prepaid rent in an amount or value in excess of 1 and 1/2 month's rent. However, the ALTA does not prohibit a tenant from voluntarily paying more than 1 and 1/2 months' rent in advance. The breakdown of deposit amounts shown below is solely for the purpose of showing how such amounts were calculated and does not limit a landlord's rights to use all deposit amounts as permitted by the ALTA. Deposits may be placed in interest-bearing accounts, which interest shall be retained by the broker or landlord. Refundable deposits shall not be used as a credit towards last month's rent. So here you put refundable security deposit. Security deposit, you put the money per deposit. You put the cleaning deposit. Non-refundable deposit charges due. Cleaning fee. recording fee, pet cleaning fee, other fee, taxes due on initial rent, and non-refundable charges paid to the landlord, sales tax, total requirement, less earnest money balance due, and there's the refundable deposit will be held. All right, line 85. No refundable deposit shall be transferred from the broker's trust account to anyone other than the tenant without 10 calendar days written notice to tenant. If deposits are held by landlord, tenant and landlord agree to hold broker harmless of all liability regarding said deposits. If the premises are surrendered to landlord at the termination or expiration of this lease agreement in a clean and undamaged condition acceptable to landlord, landlord shall return the refundable deposit to tenant within the time period provided for in the ALTA. However, if the premises are delivered to landlord in an unclean, damaged, or unacceptable condition, the landlord shall be entitled to retain all or a portion of the refundable deposit and hold tenant liable for any additional changes or charges. So here, this paragraph basically says, you want to return the room like you found it. But if it's damaged, landlord can charge the security deposit. Application, credit, background contingency. A credit background report application fee of this amount of money is due by separate payment and is non-refundable. This lease agreement is contingent on satisfactory verification and approval by the landlord of tenant employment, credit, banking references, income, past rental history, and criminal and or other background checks prior to possession. Tenant consents to these credit background checks by landlord or broker. Tenant shall complete a separate rental and or credit application containing all the required information. Tenant warrants that the information is correct and complete, and the tenant has disclosed all pertinent information and has not withheld any information, including but not limited to poor credit, early termination of leases, evictions or bankruptcy, tenant's material, falsification of any information provided to landlord shall entitle landlord to terminate his lease agreement and pursue all applicable remedies, damages, court costs, and reasonable attorney fees. The credit history of tenant with respect to his lease agreement may be reported to any credit bureau or reporting agency. Pets, including but not limited to animals, fish, reptiles, or birds, assistive and service animals, are not considered pets. So let me read that again. Assistive and service animals, are they considered pets? No. So if you have a pet, but it assists someone based on the disability, or they're a service animal based on a disability, are they considered a pet? No, they are not. So no pets allowed. You mark there. Tenant agrees to not to keep or permit any pets on the premises without prior written consent of landlord. And then check that box. Landlord hereby grants tenant permission to keep the following described pets on the premises. You can put is required, is not required to maintain a liability insurance policy to cover any liability incurred due to pet with the minimum of this dollar value. Keys. Landlord agrees to deliver to tenant keys from premises, garage door openers. Upon possession, tenant shall pay rent and shall remain responsible for the security of the premises until all keys and garage doors openers have been physically returned to the landlord, property manager, authorized representative, or otherwise satisfactory accounted for by tenant. Leaving the keys in the garage door opener, entry gate opener in or on the premises will not be considered a return unless expressly authorized by landlord in writing. Tenant agrees to pay all costs related to replacing lost or unrelated keys in a garage door entry gate opener. Tenant shall not change the locks or add a deadbolt lock without the landlord's written consent. Tenant acknowledges that, unless otherwise provided herein, premises have not been rekeyed. Utilities. Tenant agrees to arrange and pay for when due all utilities except blank. You can fill it in. Association premises is located within a community association, yes or no. So here's where you want to see if it's an HOA. Association dues, if applicable, homeowner and other association dues and assessments shall be paid by the landlord. Maintenance responsibility, the following shall be the responsibility of the party indicated. So you can mark there: pool maintenance, cleaning and routine maintenance, pool chemicals. So, you're going to dilly dally. Who's going to be responsible for the pool? Landlord, tenant, association, or NA? B, routine pest control. So who covers that? The landlord, the tenant, association, or not applicable. Yard maintenance, front yard, backyard, other. Upkeep of the premises. Tenant has completed all desired physical, environmental, or other inspections and investigations of the premises and is satisfied with the physical condition except as otherwise noted in writing. Tenant shall maintain the premises in a neat and undamaged condition, and in particular shall comply with applicable provisions of building codes, homeowner association, or other rules and regulations. Maintain the premises in a clean and safe condition. Dispose of all ashes, rubbish, garbage, and other waste. Keep and use all plumbing and electrical, sanitary, heating, ventilating, and air conditioning facilities and elevations and other facilities and appliances in a clean and reasonable manner, and generally conduct themselves and others in their charge, including pets, in a manner so as not to disturb their regulations or in any way deface, damage, impair, or otherwise destroy any part of the premises. Tenant shall immediately notify landlord of any situation or occurrence that requires landlord to provide maintenance. All right, make repairs or otherwise requires landlord to take action as required by the ALTA, including but not limited to any moisture condition, Okay, rules and law. Tenant has either received a copy of any rules, regulations, covenant, condition, or restrictions, homeowners association rules, ordinances and laws, rules and law concerning the premises, or has made an independent investigation of the applicability of any such rules and law to tenants' use of the premises. If the homeowner association, state, county, municipal, or other government bodies adopt new ordinances, rules, or other legal provisions affecting this lease agreement, landlord may make immediate amendments to bring the lease agreement into compliance with the law. In such event, landlord agrees to give tenant notice that this lease agreement has been amended and shall provide a brief description of the amendment and the effective date. Compliance with rules and law. Landlord and tenant agree to comply with the applicable rules and law concerning the premises. Tenant agrees to supervise other occupants, family guests, invitees, or other persons under tenant's control to ensure their compliance with the rules and law and shall be responsible for any actions of the foregoing who violate this lease agreement or the applicable rules and law. Tenant shall immediately notify landlord upon receipt of any notice of violation and shall pay any fines or penalties assessed by any governing body as a result of tenant's non-compliance with rules and law. So tenant has to sign that. Basically says that the tenant, whoever signs this, is responsible for any guests they bring over. Crime-free provision. Tenants, occupants, family guests, invitees, or other persons under tenant's control shall not engage in or facilitate any acts involving immediate or actual serious property damage as defined by law. Any criminal activity, state, federal, or other municipality, including drug-related criminal activity, any act of violence or threats of violence, other illegal activity, including prostitution, criminal street grading activity, threatening or intimidating, unlawful discharge of firearms or assault, jeopardize the health, safety, and wellness of tenants, landlord's representatives, agents, or others. Violation of this provision shall constitute a material and irreparable violation of the lease agreement and cause for immediate termination of the tenancy. So basically, if you're caught doing any of these things, the tenancy ends right then and there, right? So I'm gonna go back. Any criminal activity, state, federal, or other municipality, including drug-related criminal activity. So any drugs, right? Any act of violence or threats of violence. So say you have a tenant and they're being violent, right? Um, maybe you rented to a couple. I've actually had this in the past where one hurt the other and caused the police to come. That would end the tenancy. That would terminate immediate termination of the tenancy, right? Or a threat, even a threat of violence, you can end immediate termination of the tenancy. Um, any drug related activity. So if they're doing, any type of fentanyl or heroin or meth, you can end the tenancy there. Or if they are acting violent, or if they're threatening violence, you can end the tenancy there. Other illegal activity, right? If they are doing prostitution, criminal street grading activity, right? If they're hanging out and they're in a gang, you can end the immediate termination of tenancy. Threatening or intimidating, right? What if they're intimidating you, right? You feel intimidation. Well, you can end the tenancy there. Immediate. Unlawful discharge of firearms. That's if they start firing gunshots. Yeah, that's end of termination. Or assault, right? Or if they jeopardize the health, safety, and welfare of tenants. So if they're affecting other tenants, landlord, landlord's representative, agents, or others. Swim pool barrier. Tenant agrees to investigate all applicable state, county, and municipal swimming pool barrier regulations and agrees to comply with said regulations while complying the premise unless otherwise agreed in writing. If the premises contain a swimming pool, tenant acknowledges receipt of the Arizona Department of Health Services approved prior private pool safety notice. Landlord and tenant expressly relieve and indemnify broker from any and all liable and responsibility for compliance with any applicable pool barrier laws and regulations. So tenant initials there. Lead-based paint disclosure. So if the premises were built prior to 1978, landlord shall notify tenant of any lead-based paint hazards in the premise, provide tenant with lead-based paint risk assessment or inspections of the premises in the landlord's possession, provide tenant with the disclosure. The premises were constructed prior to 1978 and tenant has received and executed the disclosure, signed there. Premises were constructed in 1978 or later, you check that box. Smoke detectors, the premises does or does not. Carbon monoxide detectors, does or does not. All right, fire sprinklers. All right, big deal here. All right, it's a big cost. The premises does or does not contain fire sprinklers. If yes, tenant shall notify landlord if the sprinklers are not working properly or are missing from the premises. Alterations and improvements. Tenant shall not make any alterations, changes, or improvements, right? Here's the key word, improvements to the premises without the landlord's prior written consent. So what if they start making a whole nother room addition, your tenant? Well, they first need to get the landlord's permission before they do any improvements, any alterations of any kind, right? So they'll, so tenants maybe starts, if you're sharing a room, move a bunch of furniture around, yeah, they need your permission. But if they're renting the whole house, maybe they're doing something else. Tenant may be held responsible for any damages resulting from unauthorized alterations, changes, or improvements, as well as the cost to restore the premises to its move-in condition. Tenant's liability. Tenant assumes all liability for persons, injury, property damage, or loss, and insurable risks except for that caused by landlord's negligence. Landlord strongly recommends that tenant obtain and keep renter's insurance. Access. Tenant shall not unreasonably withhold consent to landlord or landlord's representatives to enter into the premises, to inspect, make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary or signed or agreed services, or exhibit the premises to prospective or actual purchasers, mortgagees, tenants, workmen, or contractors. Landlord may enter the premises without consent of tenant in case of emergency. So, the house on fire is an emergency. Landlord can go in case of emergency. Landlord shall not abuse the right to access or use it to harass the tenant. Um, Except in case of emergency, tenant's written request for repairs, or if it is impractical to do so, landlord shall give the tenant at least 2 days' notice in writing of the intent to enter and enter only at reasonable times. So yeah, business hours, 9 to 5, 8 to 5, 8 to 4. Landlord shouldn't be going into someone's premises at midnight, or 2 in the morning. Reasonable times. Tenant obligations upon vacating premises. Upon termination of this lease agreement, tenant shall surrender the premises to the landlord in the same condition as when the agreement term commenced. Reasonable wear and tear accepted. All debris will be removed from the premises. Mail forwarded and keys, garage door opener, entry gate opener returned to the landlord property manager, authorized representative. Tenant shall have all utilities on until completion of the move-out inspection. Tenant may be present at the move-out inspection, and upon request, the tenant shall be notified when the move-out inspection will occur. Trustee sale notice. Per ARS 33-1331, landlord shall notify tenant in writing within 5 days of receipt of a notice of trustee sale or other notice of foreclosure on the premises. Tenant shall notify landlord immediately upon receipt of any notice of trustee sale or other notice on the premises. Landlord shall not allow the premises to be foreclosed. Death of tenant. So tenant may provide and update landlord with the name and contact information of a person who is authorized to enter the premises to retrieve and store tenant's personal property if tenant dies during the term of the lease agreement. In the event of tenant's death during the term of the lease agreement, landlord may release tenant's personal property pursuant to the ALTA. Breach. In the event of a breach of this lease agreement, the non-breaching party may proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity. A permanent station or to deploy with a military unit or as an individual in support of a military operation for a period of 90 days or more. Tenant may terminate this lease agreement by delivering written notice and a copy of tenant's official military orders to landlord. In such a case, the lease agreement shall terminate 30 days after the next monthly rental payment is due. Military permission for base housing does not constitute a charge of permanent station order. Copies and counterparts. A fully executed fast mail or electronic copy of the lease agreement shall be treated as an original. This lease agreement and any other documents required by the lease agreement may be executed by fast mail or other electronic means and in any number of counterparts, which shall become effective upon delivery as provided for herein, except that the lead-based payment disclosure statement may be signed in counterpart. All counterparts shall be deemed to constitute one instrument, and each counterpart shall be deemed an original. Entire agreement. The lease agreement and any addenda and attachments shall constitute the entire agreement between landlord and tenant, shall supersede any other written or oral agreements between landlord and tenant, and can be modified only by a writing signed by landlord and tenant. This is the entire agreement. The failure to initial any page of this lease agreement shall not affect the validity of the terms of this lease agreement. Time is of the essence. Time is of the essence in the performance of the obligations described herein. Arizona law. This agreement shall be governed by Arizona law, and jurisdiction is exclusively conferred on the state of Arizona. Waivers. No waivers by landlord of any provision herein shall be enforceable against landlord unless in writing signed by the landlord. Nor shall it be deemed a waiver of any other provision herein or of any subsequent breach by tenant of the same or any other provision. Landlord's consent to or approval of any act shall not constitute a continuing consent to or approval of any subsequent act by a tenant. Subordination. The lease agreement shall be subordinate to all present and future ground leases, mortgages, deeds of trust, and any other encumbrance consent by the landlord, and also to any modifications or extensions thereof. Tenant agrees to execute any subordination agreements or other similar documents presented by landlord within 3 days of delivery. Permission. Landlord and tenant grant brokers permission to advise the public of this lease agreement and the price and terms herein. Again, permission. Landlord and tenant grant brokers permission to advise the public of this lease agreement and the price and terms herein. Again, residential lease agreement. Equal housing opportunity. Landlord broker comply with federal, state, and local fair housing laws and regulations. Construction and language. The language of this lease agreement shall be construed according to its fair meaning and not strictly for or against either party. All singular and plural words shall be interpreted to refer to the number consistent with circumstances and context. Court modification. If any provision of this lease agreement is found by a court to be invalid, illegal, or vague, the parties agree that such provision shall be modified or stricken by the court to the minimum extent deemed necessary to make it valid, legal, and enforceable, and that all other provisions of this lease agreement shall remain in full force and effect. Days. All reference days in this lease agreement, shall be construed to as calendar days, right? So Monday to Friday, those are calendar days. Saturday, Sunday are not. It's not a calendar day. It's a business, or those are calendar days. Sorry, Monday through Sunday, right? Saturday, Sunday, those are business. Those are not. Monday through Friday is business days. And a day shall begin at 12 a.m. and end at 11:59 p.m. Notices, unless otherwise provided for by statute or by agreement of the parties, all notices herein shall be in writing and shall be delivered to landlord at the address set forth herein, and to tenant at the premises and shall be sent by registered or certified mail or personally delivered. Such notice shall be deemed received on the date the notice is actually received or 5 days after the date the notice is mailed by registered or certified mail, whichever occurs first. All right, tenant acknowledgement. By signing below, tenant acknowledges that letter I, a free copy of the Arizona Residential Landlord and Tenant Act is available through their Department of Housing. Landlord shall furnish upon move-in a move-in form for specifying and existing damages of the premises, and tenant shall return the completed move-in form to the landlord within 5 days, five, the number 5 days, or blank days of occupancy, or tenant accept the premises in its existing order condition. Tenant is hereby notified that tenant is entitled to be present at the move-out inspection. Tenant understands and agrees to the terms and conditions of the lease agreement and acknowledges the receipt of a copy of all 8 pages of the lease agreement and any addenda. So this just states that it's 8 pages long. Um, Indemnify and release. The parties to the lease agreement agree to indemnify and hold harmless brokers, property managers, and any of their respective agents, representatives, or employees from any loss, claim, liability, or expense arising from injury to any person or damage to or loss of any property in any way caused by the parties and tenants, family, guests, invitees, agents, pets, or others under their control. Landlord's initials, tenant's initials. Terms of acceptance. The offer will become binding lease agreement when acceptance is signed by landlord and a signed copy delivered in person by mail, fast mail, or electronically and received by broker on behalf of tenant if applicable, or by tenant no later than blank at this time, Mountain Standard Time. Tenant may withdraw this offer at any time prior to receipt of landlord signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn. Okay, residential lease agreement. This lease agreement contains 8 pages exclusive of any addenda. Wait a second. So 292, we're at 293 now. Hmm. Okay, so here we are, page 7 of 8. So this lease agreement contains 8 pages exclusive of any addenda and attachments. Please ensure that you have received and read all 8 pages as well as any addenda and attachments. So broker on behalf of tenant will sign there. The landlord acceptance, broker on behalf of landlord signs there. Broker is not authorized to receive notices or act on behalf of landlord unless indicated below. Agency confirmation, the broker is the agent of property manager, if any, authorized to manage premises and act on behalf of landlord pursuant to separate written agreement. Person authorized to receive service of process, notice, and demands. Landlord acknowledgement. Landlord has read the entire lease agreement. Landlord acknowledges that landlord understands the terms and conditions contained herein. Landlord accepts and agrees to be bound by the terms and conditions of this lease agreement. Landlord has received a signed copy of this lease agreement and directs the broker to deliver a signed copy to tenant and to any other broker involved in this lease agreement. Landlord acknowledges that landlord has provided the required information for residential rental property to the applicable county assessor. Okay, so they check the counteroffer. So say you don't accept this and you want to do a counteroffer. Counteroffer is attached, which is incorporated herein by reference. If there is a conflict between the lease agreement and the counteroffer, the provisions of the counteroffer shall be controlling. Note, if this box is checked, landlord should sign both lease agreement and the counteroffer. Check this box, offer rejected by the landlord or property manager if authorized. And for broker use only, brokerage file, log number, manager's initials, broker's initials, and the date. All right, so next up, we're going to talk about real estate agency disclosure and election. So whenever you're going to do a deal with an agent or a broker, you need to disclose and elect them. So this document is not an employment agreement. The pre-printed portion of this form has been drafted by the Arizona Association of Realtors, AAR. Any change in the pre-printed language of this form must be made in a prominent manner. No representations are made as to the legal validity, adequacy, and or effects of any provision, including tax consequences thereof. If you desire legal, tax, or other professional advice, please consult your attorney, tax advisor, or professional consultant. So you'll put the firm name, you'll line 2, acting through a licensee name. Line 3, hereby makes the following disclosure. Here's the disclosure. Before a seller or landlord, hereinafter referred to as seller, or a buyer or tenant, hereinafter referred to as buyer, enters into a discussion with the real estate broker or licensee affiliated with the broker, the seller and the buyer should understand what type of agency relationship or representation they have with the broker in the transaction. So line 7, line 1, buyer's broker. A broker other than the seller's broker can agree with the buyer to act as the broker for the buyer. In these situations, the buyer's broker is not representing the seller, even if the buyer's broker is receiving compensation for services rendered, either in full or in part, from the seller or through the seller's broker. A. A buyer's broker has the fiduciary duties of loyalty, obedience, disclosure, confidentiality, and accounting in dealings with the buyer. So we call it carload, right? Care, obedience, um, disclosure, confidentiality, and accounting. Other potential buyers represented by a broker may consider, make offers on, or acquire an interest in the same or similar properties as confidentiality and accounting in dealings with the seller. Other potential sellers represented by broker may list properties that are similar to the property that seller is selling. Broker representing both the seller and buyer. Limited representation broker. A broker either acting directly or through one or more licensees within the same brokerage firm can legally represent both the seller and the buyer in a transaction, but only with the knowledge and informed consent of both the seller and the buyer. In these situations, the broker, acting through its licensee, represent both the buyer and the seller, with limitations of the duties owed to the buyer and the seller. A. The broker will not, without written authorization, disclose to the other party that the seller will accept a price or terms other than stated in the listing, or that the buyer will accept a price or terms other than offered. So if you accept two parties, right, and one is selling it and they say we want 400,000, and your buyer says, what's the lowest he can go? Will he go 390? And the agent says, yeah, we can go 390. Then you just broken your fiduciary duty. You cannot tell tell your buyer, all right, so let's submit an offer for 390. Okay, you submit an offer, and then the seller says, how did they know 390? Right? It's because you told them. You're not supposed to do that. You're not allowed to do that. Don't tell them the bottom number. You know, if the listing is 400, hey, make your best offer for 400K. Right? Make your best offer. Right? What's the minimum your seller's allowed to take? We said in the price 400K. We want 400K. Um, if you submit less than 400K, I mean, the seller will consider it, right? We'll see. We'll see how it goes. Okay. um, Regardless of who the broker represents in the transaction, the broker shall not exercise reasonable skill and care in the performance of the broker's duties, and shall be truthful and honest to both the buyer and seller, and shall disclose all known facts which materially and adversely affect the consideration to be paid by any party, pursuant to ARS 32-2156. Sellers, lessors, and brokers are not obligated to disclose that a property is or has been 1. The site of natural death, suicide, homicide, or any crime classified as a felony; 2. Owned or occupied by a person exposed to HIV or diagnosed as having AIDS or any other disease not known to be transmitted through common occupancy of real estate; or 3. Located in the vicinity of a sex offender. Sellers or sellers' representatives may not treat the existing terms or conditions of offers as confidential unless there is a confidentiality agreement between the parties. The duties of the broker in a real estate transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. The seller and the buyer should carefully read all agreements to ensure that the documents adequately express their understanding of the transaction. So, I mean, this goes again, protect yourself at all times. You are going to use a broker or a realtor to help you in the transaction, but you still need to know and read all the documents and understand all the documents. Be of sound mind. Election. Agency election does not establish broker compensation. Compensation paid by a buyer or seller to their broker is not set by law, is always fully negotiable, and the amount chosen shall be documented in a separate written employment agreement after discussion with their broker. Should a seller also choose to offer compensation to a buyer's broker, the offered amount is also not set by law, is fully negotiable, and agreed upon after discussion with the seller's broker. So buyer seller initials required here. So this is the latest and greatest document. This was updated November 2024. Buyer or tenant election, you'll check there. If you're the buyer, seller, we'll check there. If you're the seller, right, the undersigned buyer or seller acknowledges that this document is a disclosure of duties. So what is this document really all about? It's just disclosing the duties of your realtor or your broker. So this is the real estate agency disclosure and election, right? Who's representing you, right? But you're not putting on here the compensation. This document is just what are the duties, what does your realtor owe you? What are the services that you're getting into? Next up, this is the buyer tenant employment agreement addendum. This was revised August of 2024. And it's in the transaction desk in Arizona Association of Realtors AR form. Okay, here's the buyer tenant employment agreement addendum. So line 1, the buyer tenant puts their name there, the broker's name there, agreement name. All right, cancellation. You may or may not need this document. Wire fraud advisory. Okay, wire fraud advisory. So criminals are targeting social media and email to steal information. This is particularly common in real estate transactions because sensitive data, including social security numbers, bank account numbers, and wire instructions, are often sent by electronic means. We do not want you to be the next victim of wire fraud. Money wired to a fraudulent account is stolen money that typically cannot be recovered. Additionally, there is generally no insurance for this loss. You may never get the money back. So when you send a wire over, you have to make sure you're sending the right wire to the right person. So you want to protect yourself. So do not trust emails containing wire instructions. If you receive an email containing wire transfer instructions, immediately call your escrow officer to ensure the validity of the instructions. So when you're doing a deal, we deal with escrow, title company, call them first and get the wire instructions from them. Do not trust emails seeking personal financial information. If you receive an email requesting personal financial information or asking you to download, click on a link, send, and or do anything that may seem unusual to you, call your escrow officer immediately prior to acting on the suspicious email to verify the validity of the email. Trust your source of information. Never direct, accept, or allow anyone in the transaction to consent to receiving transfer instructions without a direct personal telephone call to the individual allegedly providing the instructions. So before you send over a wire, call the person, call your call the escrow title company to ensure you're doing the right, sending the right transfer wire. It is imperative that this call be made to a number obtained in person from the individual or through other reliable means. not from a number provided in the email or the wiring instructions. So again, it is imperative that this call be made to a number obtained in person from the individual or through other reliable means, not from a number provided in the email or the wiring instructions. Online resources. So there may be many online sources that can provide useful information regarding similar topics, including but not limited to the following sites: the Federal Bureau of Investigation, FBI. So you can go to www.fbi.gov/scams and safety. The Internet Crime Complaint Center, www.ic3.gov. The National White Collar Crime Center, www.nw3c.org/services/research/cybercrime links. On Guard Crime, go to www.onguardonline.gov. You have CFPB, Consumer Financial Protection Bureau. So go to consumerfinance.gov. /about-us/blog/mortgage closing scams, how protect yourself and your closing funds. So verify, notify. Before you wire funds to any party, including your lawyer, title agent, mortgage broker, or real estate agent, personally meet them or call a verified telephone number, not the number in the email, to confirm you before you act. Immediately notify your banking institution and settlement title company if you are a victim of wire fraud. The undersigned acknowledge receipt of this wire fraud advisory. All right, next up, so we talked about wire fraud advisory. Now we're going to talk about tenant advisory. So this was updated August 2019 on Transaction Desk under the Arizona Association of Realtors AR forms. Tenant advisory. So the tenant advisory is a resource provided by the Arizona Association of Realtors. Residential rentals are required to comply with this link here, verification of ownership. So prior to executing a lease agreement or conveying any money, tenants should immediately verify the owner of the property and confirm that they are contracting with the owner of record. If a person other than the owner signs a lease agreement, tenants should verify that the third party has authority to act on the owner's behalf. Information regarding property ownership can often be found by county at the following: Arizona County Assessors. Wire fraud. Beware of wiring instructions sent via email. Cyber criminals may hack email accounts and send emails with fake wiring instructions. You should independently confirm wiring instructions in person or via a telephone call to a trusted and verified phone number prior to wiring any money. Common documents a tenant should review. So 1. Residential lease agreement. Tenants should protect themselves by taking the time to read the residential lease agreement and understand their legal rights and obligations before they enter into a lease agreement. So click to view a sample of the agreement here. Residential lease owner's property disclosure statement. It's kind of like the SPUDs. Many landlords provide a RLOPDS, residential lease owners. So it's not a purchase SPUD, but it's a lease SPUDs, right? It's going to document all the anything wrong with the property from the seller or from the lease owner. This document poses a variety of questions for the owner to answer about the property and its condition. The property manager broker is not responsible for verifying the accuracy of the items on the RLO PDS. Therefore, a tenant should carefully review the RO and verify those statements of concerns. Right? So When a seller's going to sell their house, they have to fill out the SPUDs, seller property disclosure statement. But when the owner is going to lease their property, they have to fill out a residential lease owner property disclosure, RSPUDs, RLO SPUDs. Homeowner Association, HOA governing documents. If CC&Rs are recorded against the property, the tenant agrees to follow the CC&Rs. It is essential that the tenant review and agree to these restrictions prior to leasing a property. The Arizona Department of Real Estate, ADRE, advises read the deed restrictions, also called CC&Rs, covenant conditions and restrictions. You might find some of the CC&Rs are very strict. That's why they call CC&Rs covenant conditions and restrictions. In addition to CC&Rs, HOAs may be governed by articles of incorporation, bylaws, rules and regulations, and often architectural control standards. Read and understand these documents. Also be aware that some HOAs impose fees. Tenants with questions about their rights and remedies regarding homeowner association or community association should read the information provided at Arizona Department of Real Estate. So again, tenants with questions about their rights and remedies regarding homeowners association or community association should read the information provided by ADRE at azre.gov/publicinfo/real estate research topics.aspx. This is going to be under ARS 33-1260, ARS 33-1806. Lead-based paint disclosure form. If the home was built prior to 1978, the landlord must provide the tenant with a lead-based paint disclosure form. Information about lead-based paint may be obtained at Arizona Department of Real Estate. Move-in or move-out inspection. The importance of inspecting the property at the time of moving in cannot be overemphasized. The tenant is encouraged to fill out a move-in, move-out checklist to identify material defects in the property within the stated time frame. A sample of AR's move-in, move-out condition checklist can be viewed at this website. Tenants should keep a copy of the checklist for their records and may also want to take photographs of any damage observed at the time of move-in. Okay, so this is page 1 of 4 of the tenant advisory. So this is a resource for real estate consumers provided of the Arizona Association of Realtors, AR. So notice, unless otherwise agreed, all notices shall be sent registered or certified mail or personally delivered. ARS 33-1313. So again, unless otherwise agreed, all notices shall be sent registered or certified mail or personally delivered. So that's the first law, right? Arizona Revised Statute, that's the law, Arizona law. That's the number that it needs to be sent via mail, right? Or if you notice, repairs and property condition pursuant to Arizona law, landlord is generally responsible for ensuring that all electrical, plumbing, sanitary, heating, ventilation, air conditioning, and other facilities and appliances, including elevators, supplied by him, be in good and safe working order and condition. ARS 33-1324. So, what law says landlords are responsible for most of the maintenance? ARS 33-1324. So if you ever wonder, well, who's responsible for this? The AC. Should the tenant pay for the AC? Should the tenant pay for sanitary or plumbing or electrical? No, it's the landlord, right? It is the landlord's responsibility to make sure that necessary repairs are made to keep the property in a fit and livable condition. It is the tenant's responsibility to notify the landlord of any or all necessary repairs. Following proper notice, the landlord has 5 days to make any repairs that materially affect the health and safety of the tenants and 10 days to make any other requested repairs. Note, pursuant to ARS, the landlord and tenant of a single-family residence may agree in writing, supported by adequate consideration, that the tenant will perform the landlord's duties to maintain a fit premises and perform unspecified repairs. Access to the property by landlord or landlord's representative. Unless the tenant requests repairs in writing, the landlord must give the tenant at least 2 days' notice to enter the property. During reasonable hours to make repairs, conduct inspections, have services completed, or exhibit the property to prospective purchasers and tenants. The landlord has the right to immediately enter the premises in the event of an emergency or by court order. ARS 33-1343. So, in case of emergency, can the landlord go in? Yes. What law is that? 33-1343. Deposit fees. The lease agreement should specify which deposit fees are refundable and which are not. A landlord is not permitted to demand refundable security in an amount in excess of 1.5 months' rent. So, how much security can you get? You get 1 and 1.5. Can you get 2 times the security deposit? No. Can you get 3 times security deposit? No. 4? No. During the term of the lease, so in other states you can, but in Arizona we're limited to 1 and 1.5. So I've talked to other folks where they've actually got security deposits of like 3 or 4 times, and Arizona we're limited. You can only ask for a security deposit of 1 or 1.5. During the term of the lease, the tenant security deposit should be held by the landlord or in a broker's trust account. Disclosed in writing. At the end of the lease, all refundable deposits shall be refunded to the tenant pursuant to ARS 33-1321G. The landlord can subtract unpaid rent or repair costs from the security deposit. So they put, tenant example scenario, tenant puts a hole in your wall. Can you subtract the security deposit? Yes. Unpaid rent, so they don't pay rent next month. Can you use that security deposit? Yes. Within 14 business days after termination of the tenancy and delivery of possession and demand by the tenant is either entitled to receive an itemized list of any all security deposit deductions together with the amount due and payable to the tenant. ARS 33-1321D. Number 5, termination of the lease. These are really nice because all of these notices has the actual law, ARS law, right next to it. Unless the parties desire for the lease agreement to continue, written notice of intent not to renew the lease agreement shall be issued pursuant to the terms of the lease. If the lease continues on a month-to-month basis, absent prior written agreement, either the lease owner or the tenant may terminate by providing 30-day written notice prior to the periodic rental date, i.e. the date which rent is due, per ARS 33-1375B. If the tenant vacates the property before the lease expires, they can still be held responsible for damages, including but not limited to monthly rent, right? So damages includes rent. So could you say, okay, I didn't damage the property, but you didn't pay the rent, that's a damage, right? A holdover tenant is someone who stays in the lease property after the express terms of the lease has expired. So you tell your tenant to leave and they don't. What are they called? A holdover tenant. The landlord can choose to evict a holdover tenant or allow the tenant to continue living in the property on a month-to-month basis under the terms and conditions of the lease agreement. Foreclosure, the landlord shall not allow the property to become the subject of a trustee's sale, and doing so may place the landlord in breach of the lease agreement. Nonetheless, a landlord's failure to pay the mortgage does not eliminate the tenant's obligation to pay rent. So again, nonetheless, a landlord's failure, so if the landlord fails to pay the mortgage, does not eliminate the tenant's obligation to pay rent. To avoid breaching the lease, the tenant should continue paying rent to the landlord up to the date on which the foreclosure is completed. So just because the property is going to foreclosure doesn't mean the tenant shouldn't pay no more. Insurance, tenants are strongly encouraged to obtain renter's insurance for their benefit pursuant to some lease agreements. Certain pets may require additional insurance coverage. Tenants are encouraged to contact an insurance professional concerning additional coverage that may be required. Fair housing and disability laws. The Fair Housing Act prohibits discrimination based on race, color, national origin, religion, sex, familial status, including children under the age of 18 living with a parent or legal custodian, pregnant women, and people securing custody of children under the age of 18. And disability. Visit HUD's Fair Housing Equal Opportunity website at HUD.gov, program offices, Fair Housing Equal. Okay. Additional information, pests, pests, bed bugs. So, bed bug infestation is on the rise in Arizona and nationally. For more information on rights and obligation with respect to bed bugs, visit the following websites here. It's going to be cdc.gov/parasites/bedbugs. Scorpions. Information on scorpions may be found here. Swimming pools and spas, barriers. Each city and county has its own swimming pool barrier ordinance, and tenants should investigate and comply with all applicable state, county, and municipal pool regulations. So, what city do you live in? What county do you live in? What pool barriers are required, right? Typically, what I've seen in my experience where I live in, you need a pool barrier if you have children under 4, I think under the age of 4 or below. You don't if you don't have any children under 4 or below. Where I am currently located, which is Coolidge, Arizona. Pool barrier. Okay. Arizona Department of Health Services private pool safety notice may be found here. State law on swimming pools is located here. Sex offenders. The presence of a sex offender in the vicinity of the property is not a fact that the landlord or broker is required to disclose. So if you have a sex offender living next door to you, does your broker have to tell you? No. Does the landlord have to tell you? No. has maintained a registry and community notification program for convicted sex offenders. So if you want to know who are the sex offenders in your area, go to azdos.dps.gov/service/public/offender, or through the National Sex Offender Public website here at www.ms.gov/en. Prior to June 1996, registration was not required, and only the higher risk sex offenders are on the website. Additional resources, links to state agencies. Okay, links to agencies, city and county websites, Arizona Tenants Rights, Responsibilities Handbook. Those are additional resources. Arizona Department of Real Estate Consumer Information here. Find a realtor here for information on indoor environmental concerns. The EPA has a host of resource materials and pamphlets which are available here. Crime stats in all Arizona cities, go to here. Tenants. So at leagueaz.org, you can click on the city, town, and search for crime statistics. You can figure out the demographics, crime. Tenants may find that children cannot attend the school nearest to the property and may even be transported to another community. For information about schools, visit this site. United States Department of Housing and Urban Development. Housing Choice Vouchers fact sheet can be found at the following site here. Information regarding Section 8 programs available through the Arizona Public Housing Authority can be found here. Call 602-771-1000. So if you want to put your house on Section 8, you can do that. Maps for military airports can be found here. Maps for many of the public airports can be found here. And then tenant acknowledgement to this tenant advisory. So tenant signs there. A resource for real estate consumers provided by the Arizona Association of Realtors, AR. It's a very good resource. So tenant acknowledgement receipt of all 4 pages of this advisory. Tenant further acknowledges that there may be other disclosure issues of concern not listed in this advisory. Tenant is responsible for making all necessary inquiries and consulting the appropriate person or entities prior to the leasing of any property. The information in this advisory is provided with the understanding that it is not intended as legal or other professional services or advice. These materials have been prepared for general information purposes only. The information and links contained herein may not be updated or revised for accuracy. If you have any additional questions or need advice, please contact your own lawyer or other professional representative. So this is just tenant advisory, some advice, really. All right, so next up, so we talked about tenant advisory. Now we're going to read the buyer broker exclusive employment agreement found on transaction desk, written by AAR, written by the Arizona Association of Realtors. So these forms, who are they written by? The Arizona Association of Realtors. So buyer broker exclusive employment agreement. So notice to the buyer, all realtors are required to have a signed written agreement prior to showing a home to a buyer. So some buyers think, I don't want to sign anything with a realtor. I want to go see a house. Well, we are bound to have some sort of written agreement before we show you a house, right? Bound by the buyer broker exclusive employment agreement. Exclusive employment, right? So we're going to get paid. This is an employment contract. So this was revised this year, August 2024. So buyer puts their name there, broker puts their name there, agent puts their name there, acting through broker, put their real estate company. Okay, agreement. So this buyer broker exclusive employment agreement is between the buyer and broker in consideration of broker's agreement to assist buyer to locate, negotiate, and facilitate the purchase of a property. Buyer gives broker the exclusive and irrevocable right to represent buyer in the purchase of a property during the term. Buyer acknowledges that signing more than one buyer-broker exclusive employment agreement or similar agreements could make buyer liable to compensate multiple brokers. So say you got a buyer, right, and he wants like 5 agents to represent him. Well, he's going to be liable for 5 commissions. So you need to let him know that, and he shouldn't do that. You should work with one agent only. Term, this agreement shall commence on this date and expire 11:59 p.m. Mountain Standard Time on this date. So, any document you have, you should have a start date, an end date, and when does it expire. So this agreement commences on this date, and usually you can put out 6 months. It expires in 6 months. Employment broker agrees to locate property meaning the following general description: residential, land, commercial, other. B, negotiate at buyer's direction to obtain acceptable terms and conditions to the purchase, exchange, or option of the property. C, assist buyer during the transaction within the scope of broker's expertise and licensing. Agency relationship. The agency relationship between buyer and broker shall be as set forth in the real estate agency disclosure and election form. Other property viewings. Buyer agrees to work exclusively with broker and be accompanied by broker or buyer's first visit to any property. If broker does not accompany buyer on the first visit to any property, including a model home, new home, or open house held by a builder, seller, or other real estate broker, buyer acknowledges that the builder, seller, or seller's broker may refuse to compensate broker, which will eliminate any credit against the agreed upon broker compensation below. So most new builds requires the seller to be there. The buyer's broker to be there. So that's why this paragraph is here. Buyer agrees to review the Arizona Department of Real Estate buyer advisory to assist the buyer's inspection and investigations. The broker compensation is not set by law, nor by any board, association of realtors, multiple listed service, or in any manner other than as fully negotiated between broker and buyer in this agreement. So buyer initial there just says that compensation is not. There's no set amount, and you know that. Retainer fee. So check if applicable buyer agrees to pay broker non-refundable retainer fee in the amount of $1 right there within 5 days or blank days of execution of this agreement, which is earned when paid for initial consultation, research, and other services. The fee shall or shall not be credited against the broker compensation below. Broker compensation if buyer or any entity owned or controlled by buyer closes escrow on a transaction for the purchase, exchange, or option of a property. Buyer agrees to compensate broker as follows. Broker compensation, so check only one and fill in the compensation blank percent of the full purchase price or exchange value or a dollar value or other. The broker compensation shall be in United States currency and paid at the time of and as a condition of closing for purchase or exchange or as otherwise agreed upon in writing. Compensation from seller or seller's broker. A seller or seller's broker may offer compensation to broker. Buyer authorizes broker to accept compensation from seller or seller's broker, which shall be credited against broker compensation. If seller or seller's broker offer of compensation is greater than the broker compensation, broker shall be paid the broker compensation, and the balance shall be credited to buyer to the extent allowed by buyer's lender. Broker will not receive any amount greater than broker compensation from any source for services provided in this agreement. If seller or seller's broker's offers of compensation is less than the broker compensation, buyer may request seller to pay the broker compensation as part of an offer to purchase the property. Any broker compensation not paid by seller or seller's broker shall be paid by buyer. Notice, unless modified by VA regulations, VA financial transactions shall be conditioned upon the broker compensation being paid by the seller or seller's broker. B. Failure to complete. Once an acceptable party is located, buyer agrees to act in good faith to acquire the property and conduct any inspections or investigations of the property that buyer deems material and or important. If completion of any transaction is prevented by buyer's breach or with the consent of buyer other than as provided in the purchase contract, the broker compensation shall be due and payable by the buyer. Compensation after expiration date. After the expiration date of this agreement, buyer agrees to pay broker compensation if, within blank calendar days after the expiration date, buyer enters into an agreement to purchase, exchange, or option any property shown or negotiated by broker on behalf of buyer during the term of this agreement, or buyer closes escrow on a property pursuant to a purchase contract that was executed during the term of this agreement, or 3, buyer closed escrow on a property for which escrow was opened during the term of this agreement. Listings. Broker shall show property listings that fit buyer's criteria, regardless of the compensation offered to broker by seller or seller's broker, unless instructed otherwise by buyer in writing. If necessary, buyer instructs broker to negotiate broker compensation be paid by seller or seller's broker. These negotiations shall not jeopardize, delay, or interfere with the initiation, processing, or finalizing of a transaction. Notice, if buyer decides they do not wish to view the property listings unless the seller or seller's broker has offered adequate compensation to broker, the buyer must make that instruction to broker in writing. Equal housing opportunity. Broker's policy is to abide by all local, state, and federal laws prohibiting discrimination against any individual or group of individuals. The broker may not disclose the racial, ethnic, or religious composition of any neighborhood, community. So again, broker may not disclose, right? Broker may not disclose the racial, ethnic, or religious composition of any neighborhood, community, or building, nor whether persons with disabilities are housed in any home or facility, except that broker may identify housing facilities meeting the needs of a disabled buyer. For more information, consult the Fair Housing Advisory. Other potential buyers. Buyer consents acknowledge that other potential buyers represented by broker may consider, make offers on, or acquire any interest in the same or similar properties as buyer is seeking. So again, your broker has lots of buyers. And if you're making an offer on one and you're thinking about buying one, you got to make an offer first come, first serve. Release of broker. Buyer recognizes, acknowledges, and agrees that broker is not qualified nor licensed to offer advice on financial, legal, or tax matters regarding real estate transactions. Related services. So again, release of broker. Buyer recognizes, acknowledges, and agrees that broker is not qualified, right? Your broker, they're not qualified nor licensed to offer advice on financial, so money, legal, so any ARS laws, or tax, right? CPAs matter regarding real estate transactions. Broker, if requested, may provide buyer the names of third-party professionals who claim to perform related services. Buyer is instructed to independently investigate all potential third-party professionals and use their sole discretion in selecting which third-party professionals to hire. If any, buyer expressly releases, holds harmless, and indemnifies broker from any and all liability and responsibility regarding buyer's selection and use of third-party professionals to perform related services, or buyer's election not to use the services of such third-party professionals. The buyer's line is there. So what this is saying is, if you want to ask your realtor about taxes, they can give you their opinion, their experience, but it's not to be, it's not, uh, they shouldn't be offering any advice, right? Your broker shouldn't offer any advice. You should do this, you should do that. There should be no advising, no advice. You should do this, you should do that. No advice from the broker on. Don't take any advice from the broker from finances, legal like ARS laws, or taxes. Additional terms. Alternative dispute resolution, ADR. Buyer and broker, the parties agree to mediate any dispute or claim arising out of or relating to this agreement in accordance with the mediation procedures of the applicable state or legal or local realtor association, or has otherwise agreed. All mediation costs shall be paid equally by the parties. In the event that mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In such event, the parties shall agree upon the arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association, AAA, in accordance with the AAA arbitration rules for the real estate industry. The decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered in any court of competent jurisdiction, notwithstanding the foregoing after party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to court action. The parties agree that any and all disputes or claims will be brought in the party's individual capacity and not as a plaintiff or a class member in any pur- purported class, collective, representative, or other consolidated proceeding. The parties hereby waive their right to commence, become a party to, or remain a participant in any group, representative, class, collective, or hybrid class collective action in any proceeding, and the arbitrator shall not preside over any form of a group, representative, or class collective proceeding. Buyer's initial there. Attorney fees and costs in any realtor association proceeding to enforce the compensation due to broker pursuant to this agreement. The prevailing party shall be awarded their reasonable attorney fees and arbitration costs. So whoever loses has to pay the attorney fees and costs. Arizona law. This agreement shall be governed by Arizona law and jurisdiction as exclusively conferred on the state of Arizona. Copies and counterparts. This agreement may be executed by fastmail or other electronic means and in any number of counterparts. A fully executed fastmail or electronic copy of the agreement shall be treated as an original agreement. Entire agreement. The agreement and any addenda and attachments shall constitute the entire agreement between buyer and broker and shall supersede any other written or oral agreement between buyer and broker and can be modified only by a writing signed by buyer and broker. Invalidity or unenforceability of one or more provisions of this agreement shall not affect any other provisions of this agreement. Capacity. Buyer warrants and buyer has the legal capacity, full power, and authority to enter into the agreement and consummate the transaction contemplated hereby on buyer's own behalf, on or on behalf of the party buyers represents as appropriate. Acceptance. Buyer hereby agrees to all the terms and conditions herein and acknowledge receipt of a copy of this agreement. So the buyer signs here. All right, so next up is going to be lead-based hazards disclosure rentals. Okay, this was updated in January 2009. So this is mainly for properties built before 1978 or even after 1978, just disclosing, do you need the disclosure of lead-based paint or do you not? So disclosure of information on hazard, on lead-based paint and lead-based paint hazards for rentals. Premises, address, so you put the address there, one of two. Lead warning statement. So housings built before 1978, right? What's the year? 1978. 1978. May contain lead-based paint. Lead from paint chips, and dust can pose health hazards if not taken care of properly. Lead exposure is especially harmful to young children and pregnant women. Lead poisoning in young children may produce permanent neurological damage, including learning disabilities, reduced intelligent quotient, behavioral problems, and impaired memory. Before renting pre-1978 housing, landlords must disclose the presence of known lead-based paint and lead-based paint hazards in the dwelling. Tenants must also receive a federally approved pamphlet on lead poisoning prevention. So, why is lead-based paint so bad? Well, it can affect children, right, and pregnant women. Landlord's disclosure. So, landlord must complete and initial sections A, B, and C below. So, A, lead-based paint hazards. So, landlord is aware that lead-based paint are present in the residence. So you check that if there is. If there's not, landlord has no knowledge of any lead-based paint hazards in the residence. Landlord initials there. B, records and reports available to the landlord. Check 1 or 2 below. So 1 is landlord has provided the tenant with all available records and reports relating to lead-based paint. 2, landlord has no records or reports relating to lead-based paint. Okay, landlord says there. C, landlord acknowledges his obligation to disclose to any real estate agent to whom the landlord directly or indirectly is to pay compensation with regard to the transaction contemplated by this disclosure, any known lead-based paint or lead-based paint hazards in the premises to be rented, as well as the existence of any reports or records relating to lead-based paint or lead-based paint hazards in the premises to be rented. Landlord further acknowledges that this disclosure accurately reflects the entirety of the information provided by the landlord to the agent with regard to lead-based paint hazards, and lead-based paint risk assessment or inspection reports and records. Tenant acknowledgement. So tenant must complete initial sections A and B below. Tenant has read the information set forth above and has received copies of the reports, records, or the materials referenced above, if any. So tenant initials there. Tenant has received the pamphlet, Protect Your Family from Lead in Your Home. Tenant initial there. Agent acknowledgement. Any real estate agent who is to receive compensation from the landlord or the property manager with regard to the transaction completed to this disclosure must initial below. The agent whose initials appear below has or have ensured the landlord's compliance under the Residential Resale Lead-Based Paint Hazard Reduction Act of 1992 by the landlord's use and completion of this disclosure form. Certification of accuracy. By signing below, each signatory acknowledges that he or she has reviewed the above information and certifies that, to the best of his or her knowledge, the information provided by the signatory is true and accurate. Landlord signs, tenant signs. Lead-based paint disclosure, tips for rentals of residential properties, steps for realtors to follow. So note, the lead-based paint disclosure requirements apply to all real estate agents involved in the transaction except for tenants agents receiving compensation from the tenant only. The following recommended steps are provided to help realtors meet the law's obligations in a typical residential rental transaction. Property is target housing, generally built before January 1st, 1978. This can generally be accomplished by asking the landlord the owner, If the owner doesn't know, the property manager should consult property records. The property manager should also determine if the property fails within an exemption or falls within an exemption from the lead-based paint disclosure requirements. For example, if a certified inspector has determined that the property is free from the lead-based paint and lead-based paint hazards, or if the lease is for less than 100 days with no opportunity for renewal or extension, the disclosure requirements will not apply. Even if an exemption applies, the property manager should have the owner complete and sign the disclosure form, acknowledge in writing the claimed basis for the exemption. If an exemption applies, the disclosure form need not be given to potential tenants. Number two, lead-based paint disclosure requirements become effective for all targeted housing on December 6, 1996. All target housing will require the following steps. Number three, if the property is target housing, the property manager must advise the owner of certain obligations, namely the following: one, disclose to the tenant known lead-based paint or lead-based paint hazards; two, provide the tenant any existing records, test results, reports, or other known lead-based paint information related to the presence of lead-based paint or lead-based paint hazards in the property, if any; three, provide the tenant with the pamphlet Protect Your Family from Lead in Your Home, EPA approved lead-based paint hazards; four, include disclosure and acknowledgement language as part of the rental contract or addenda. Note, the law does not require that all interested tenants must be informed, only the actual tenant. So the law does not require that all interested tenants be informed, only the actual tenant. The property manager should have the owner complete, initial, and sign the disclosure form. The property manager should obtain from the landlord any records, test results, reports, or other lead-based paint information related to the presence of lead-based paint or lead-based paint hazards in order to be ready to provide copies to a tenant making an offer to rent the property. The property manager should then initial and sign the form. Number five, the property manager should disclose to potential leasing agents that the listed property is target housing, meaning it might have lead-based paint, so if it's built before 1978, probably through the MLS or other offerings to realtors. Number six, the leasing agent, the agent working with the tenant who expects to be paid by the property manager or the owner, whether it is the tenant's agent, sub-agent, facilitator, or whatever, also has the obligation to ensure the owner's compliance. If the disclosure form has not been provided by the property manager, the leasing agent should provide the disclosure form to the property manager for the owner to complete and sign, or directly to the owner if no property manager is involved. Number seven, when the tenant is ready to make an offer on target housing, the leasing agent should provide the tenant with a copy of the disclosure form signed by the owner and the property manager together with related test results and records, if any, and a copy of Protect Your Family from Lead in Your Home. Identify these documents will be obtained by the leasing agent and the property manager before the offer is signed by the tenant, but the signed disclosure form with attachments must be provided by the tenant before the offer to rent is accepted by the owner. Number eight, the disclosure form must be initialed and signed by the tenant and the leasing agent, which should be done after the owner and the property manager have initialed and signed the form. by initializing line 32 of the AR disclosure of information on lead-based paint and lead-based paint hazards rentals form, signing the certification and complying with the other terms of the AR form. Both the property manager and the leasing agent will have met their obligations under the law. All right, next up, we're going to go over pool disclosure. So for the pool disclosure, pool safety notice and receipt. So the property, you would put the property there. By signing below, the buyer, tenants, seller, landlord of the property described above acknowledge receipt of the important notice about pool safety and the Arizona Department of Health Services policy, residential pool safety notice in accordance with ARS 36-1681. So buyer or the tenant signs there, and then seller, landlord signs there. So here is the notice. Arizona Department of Health Services, Office of Environmental Health, residential pool safety notice. So the purpose of this notice is to educate residential pool owners on the legal requirements of pool ownership and proper pool safety. Each year in Arizona, too many young children are victims of drowning or near drowning. The Arizona State Legislature recognized this threat to the health and safety of children, and we passed ARS 36-1681 to prevent children from gaining unsupervised access to residential swimming pools. In ARS 36-1681E, the legislature requires that all pool owners receive the legal requirements of pool ownership and a safety notice explaining the Arizona Department of Health Services recommendations on pool safety. Permission to quote from or reproduce this notice for non-commercial purposes granted when due acknowledgement is made. Quotation from or reproduction of this notice for commercial purposes governed by ARS 39-121.03. Pool enclosure requirements. So at a residence with a swimming pool where one or more children under 6 years of age live in the residence. So all this falls below. So number one, do you have one or more children under 6 years of age? I think I said 4 before, but correct myself, it's 6. So do you need a pool enclosure? Well, do you have children 6 or younger? No? Then you don't need a pool enclosure. Yes? Well, you need a pool enclosure. So ARS 36-1681 requires that a swim pool be protected by an enclosure, wall, fence, or barrier that surrounds the pool area, unless a local code provides otherwise. The enclosure of a below ground or above ground pool must entirely enclose the pool area, be at least 5 feet high, have no openings other than the doors or gates through which an object 4 inches in diameter can pass, have no openings, handhold or footholds accessible from the exterior side that can be used to climb the barrier, and be at least 20 inches from the water's edge. If, however, a residence or living area make up part of the enclosure required by ARS, there must be a wall, fence, or barrier located between the swimming pool or other. So if, however, a residence or living area makes up part of the enclosure, there must be a wall, fence, or barrier located between the swimming pool or other contained body of water and the residence or living area that has a height of at least 4 feet
has no openings through which a spherical object 4 inches in diameter can pass, has a gate that opens outward from the pool and is self-closing and self-latching, has no openings, handholds or footholds accessible from the exterior side of the enclosure that can be used to climb the wall, fence, or barrier, and is at a distance of at least 20 inches from the water's edge. A motorized safety pool cover that requires a key switch and meets the American Society of Testing and Materials standards on F 1346-91 for each door or window in the residence or living area that has direct access to the pool. A self-latching device that is located not less than 54 inches above the floor, and either a screwed in wire mesh screen covering a dwelling or guest room window or a keyed lock that prevents a dwelling or guest from room window from opening more than 4 inches, or for an above ground swim pool, non-climbable exterior sides which are a minimum height of 4 feet, and access ladders or steps that are removable and able to be secured when the pool is not in use. Gate requirements. So, according to ARS 36-1681 B3, any gate in either the 5 foot tall wall fence or barrier enclosing a pool, or the 4 foot tall wall fence or barrier between the residence or other living area and a pool must open outward from the pool, be self-closing and self-latching, and have a latch located at least 54 inches above the underlying ground, located on the pool side of the gate, which with the latches release mechanism located at least 5 inches below the top of the gate, and no opening greater than 1/2 inch with 24 inches of the release mechanism, or located at any height if secured by a padlock or similar device which requires a key, electronic opening, or integral combination. Arizona Department of Health Services pool safety recommendation. Never leave a child unattended in the pool or pool area, because flotation devices and swimming lessons are not substitutes for supervision. A child should always be watched when in or around the pool area. CPR, CCR instructions, and the 911 emergency number or local emergency number should be posted in the pool area. A phone should be located in the pool area or easily accessible in case of an emergency. All residential pool owners should attend water rescue and CPR, CCR classes. Life-saving equipment should be easily accessible and stored in the pool area. All gate locks and latches should be checked regularly to ensure they are working properly. A gate should never be left propped open. All items that could be used to climb a pool barrier should be removed from around the barrier. In an emergency, shout for help, pull the child from the water, call 911, and after checking the child's airway and breathing, immediately begin CPR if necessary. Note: the state requirements contained in ARS 36-6181 may be superseded by local requirements that are equal to or more restrictive than the state requirements. Right? So these are the state requirements. It's not local, right? This is state of Arizona requirements, but if you live in Phoenix, there might be more strict, or if you live in Coolidge, it might be more strict. Check with your local and city, county governments to see if they have adopted different pool barrier requirements. Pool means an in-ground or above-ground swimming pool or other contained body of water, 18 or more inches in depth, uh, wider than 8 feet at any point, and intended for swimming pursuant to ARS 36-1681A. All right, so now we're going to go over mold disclosure. It's in transaction desk, written by Arizona Association of Realtors, AR form. So mold, right? So if you have known or know about mold, this mold disclosure. So you put the address of premises. So recently, substantial attention has been given to the possible health effects of mold in homes, apartments, and commercial buildings. Mold found inside such buildings is referred to as indoor mold and is categorized as being either toxic or non-toxic. Certain types of toxic indoor molds may cause health problems in some people while triggering only common allergic responses in others. Non-toxic indoor molds are ordinarily no more than a common nuisance. The existence of indoor mold is often not detectable by a visual inspection and therefore can go undetected by real estate agents, sellers, landlords, or even professional home inspectors. The only certain way to determine if the premises you are purchasing or leasing contain harmful or toxic indoor mold or other airborne health hazards like asbestos is to retain an environmental expert to perform an indoor air quality test. If past or present existence of any toxic or non-toxic mold, water intrusion, or moisture has been disclosed to you or discovered by you, you should have that condition professionally evaluated. The broker recommends that every buyer tenant should consider having an indoor air quality test and or other health hazard test performed by an environmental expert as part of their inspection rights under the purchase contract or prior to signing their lease. This is particularly important if any of the inspection reports or disclosure documents indicate the existence of past or present moisture, standing water, visible water stains, or water intrusion in the premises. All inspections, including those to detect the existence of indoor mold or other health hazards, should be completed within the time provided for inspection in the purchase contract prior to signing the lease. Any waiver or failure on the part of the buyer tenant to complete all desired inspections and tests within the time provided in the contract lease, including those for indoor mold or other health hazards, is contrary to the advice and recommendation of the broker and agents. The brokers and agents have no knowledge of whether the premises may have either toxic or non-toxic indoor mold, and they hereby acknowledge that they have been informed of the existence of any indoor mold problems by the seller landlord or any other individual. Also, the broker and agent have not and cannot verify unless the existence of mold is plainly visible, whether or not there is now or ever has been any indication of indoor mold in the premises. If mold is visible inside the premises, it is hereby acknowledged by buyer tenant that broker and agents are not qualified to verify or identify whether the visible mold is toxic or non-toxic, or whether or not there is any existing health risk that may be associated with such mold in or on the premises. If you have any questions about indoor mold in or about the premises, or about potential health problems which may result from toxic and non toxic mold, the broker and agent strongly recommend seeking advice from an environmental expert. Buyer tenant acknowledges having received and read a copy of the foregoing information pertaining to mold. Buyer tenant agrees that if there are any questions pertaining to same, the buyer tenant will seek professional advice in a timely manner. The buyer tenant has not and will not rely on the broker and or agent to furnish such advice. The buyer tenant acknowledges that the buyer tenant has received no advice and or information other than this form pertaining to mold from either the broker, agent, and or seller landlord. Buyer tenant specifically releases, holds harmless, and indemnifies brokers and agents from any liabilities for any mold found on the premise which could have been discovered by such inspections. So the buyer signs there that they received a mold disclosure. And buyer signs there. So initials required, and buyer tenant's signature. Okay, next up is the Landlord Tenant Act. Landlord Tenant Act, last update was May of 2023 under housing.az.gov/general public/landlord/and tenant act. So this is the Arizona Residential Landlord and Tenant Act. It was updated May of 2023 under the Arizona Department of Housing. They're located on 1110 West Washington, Suite 280, Phoenix, Arizona 85007. Housing.az.gov. So go to the table of contents. This is the Arizona Residential Landlord and Tenant Act, ARS Title 33, Arizona Revised Statutes, Title 33, Chapter 10, and other pertinent statutes. So Arizona Residential Landlord and Tenant Act, Title 33, Property, Chapter 10, Residential Landlord and Tenant Act, page 3 to 29. So Articles 1, 2, 3, 4, 5, general provisions, landlord obligations, tenant obligations, remedies, other pertinent statutes, Title 33, Property, Chapter 17, Residential Rental Property, page 30. Article 1 talks about general provisions. Title 9, Cities and Towns, Chapter 12, Residential Rental Inspection Programs. Article 1 pertain to hotels and innkeepers. That's going to be Title 33, Property, Chapter 3, Landlord and Tenant. So Article 1, Obligations and Liabilities of Landlord. Article 2, Obligations and Liabilities of Tenant. Remedies of Landlord, applicability of Chapter. Title 12, Courts and Civil Proceedings. Chapter 8, Special Actions and Proceedings relating to property. Article 4 is Forcible Entry. So, Arizona Revised Statute, Title 33, Chapter 10, Arizona Residential Landlord and Tenant Act. So you got Article 1, 33-1301, talks about short title. 1302, purpose, supplementary principles of law, applicability of chapter. 33-1306, settlement of dispute, claim of right, territorial application, exclusion from application of chapter, general definitions, obligation of good faith, unconscionability, notice, terms, utility charges, prohibited provisions, separation of rents, discrimination by landlord or leaseor against the tenant with children, prohibited, classification exceptions, civil remedy, early release. Then you have Article 2, talks about landlord obligations, security deposits, disclosure, landlord supply possession of dwelling unit. Article 3 talks about tenant obligations, tenant to maintain dwelling unit, rules and regulations, access, tenant to use and occupy as dwelling unit. Then Article 4, remedies, non-compliance by the landlord, failure to deliver possession, self-help for minor defects, wrongful failure to supply heat, air conditioning, cooling, water, hot water, essential services, landlord's non-compliance as defense to action for possession or rent, fire, casualty damage, tenant's remedies to landlord, unlawful ouster, exclusion or diminution of services, failure to maintain, abandonment notice, landlord liens, remedy after termination, removal of guests, eviction action, dismissal, retaliation action, retaliatory. That's Article 5. Retaliatory conduct prohibited. Article 1. General provisions. Right. Short title. This chapter shall be known and may be cited as the Arizona Residential Landlord Tenant Act. Purpose. Underlying purpose and policies of the chapters. Simplify, clarify, encourage landlord tenant act to maintain and improve the quality of housing. Supplementary principles of law applicable 33-1303. Unless displaced by the provisions of this chapter, the principles of law and equity, including the law relating to capacity to contract, mutuality of obligations, principal and agent, real property, public health, safety and fire prevention, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause supplement its provisions. 4, we're going to discuss remedies. Article 5 is retaliation, short title, purpose. 33-1304 is applicability of chapter. This chapter shall apply to the rental of dwelling units. Any conflict between the provisions of Chapter 3 and Chapter 7 of this title with the provisions of this chapter shall be governed by the provisions of this chapter. Seems pretty circular. Administrative remedies, enhancement notices, and pleading requirements. Settlement disputes, territorial application, exclusions, general definitions are outlined here. Qualification, obligation of good faith, notice, terms, utility charges, prohibited provisions, separation of rents, discrimination by landlord or leaseor against tenant with children is prohibited, right? Classification. So a person who knowingly refuses to rent to any other person a place to be used for a dwelling for the person that the other person has a child or children, or who advertises in connection with the rental a restriction against children either by the display of a sign, placard, or written or printed notice, or by publication thereof in a newspaper of general circulation, is guilty of a petty offense. No person shall rent or lease his property to another in violation of a valid restricted covenant against the sale of such property to persons who have a child or children living with them. Okay. Early release termination for law enforcement officers. Definition is defined here. Bedbug control, landlord tenant obligations, definitions. Landlord obligations, security deposits, disclosure and tender of written rental agreement. Landlord to supply possession of dwelling unit. Landlord to maintain fit premises. Limitation of liability. Regulation of rent authority. Transfer of records on sale. Notice of foreclosure, effect on lease, damages, tenant obligations, tenant to maintain dwelling unit, rules and regulations, access, tenant to use and occupy on a dwelling unit. These are the remedies. Noncompliance by the landlord, failure to deliver possession, self-help for minor defects, wrongful failure to supply heat, air conditioning, cooling water, hot water, or essential services. So here we go. If contrary to the rental agreement or section 33-1324, the landlord deliberately or negligently fails to supply running water, gas, or electrical service, or both, if applicable, and reasonable amounts of hot water or heat, air conditioning or cooling, where such units installed and offered or essential services, the tenant may give reasonable notice to the landlord specifying the breach and may do one of the following. 1. Procure reasonable amounts of hot water. 2. Recover damages based upon the diminution in the fair rental value of the dwelling unit. 3. Procure reasonable substitute housing during the period of the landlord's noncompliance. Okay. Fire or casualty damage, tenant's remedies, noncompliance with rental agreement, failure to maintain, abandonment notice, remedies, personal property definition, acceptance of partial payments, waiver of right to terminate exception, landlord liens, distraint for rent, remedy after termination, recovery of possession limited, periodic tenancy, holdover remedies, landlord tenant remedies for abuse of access, special detainer actions, removal of guest. So, a person who is a guest of a tenant who is not named on a written lease and who remains on the premises without the permission of the tenant or the landlord is not a lawful tenant, and that person's presence in or on the premises does not constitute residency or tenancy. A person who knowingly remains on the premises without the permission of the tenant or the landlord may be removed by a law enforcement officer at the request of the tenant or the landlord who is entitled to possession of the premises. Okay, we'll take a pause here. Who is not named on a written lease and who remains on the premises without the permission of the tenant or the landlord is not a lawful tenant, and that person's presence in or on the premises does not constitute residency or tenancy. A person who normally remains on the premises without the permission of the tenant or the landlord may be removed by a law enforcement officer at the request of the tenant or the landlord who was entitled to possession of the premises. Okay, so I want to touch on 33-1378. This is a big deal. So, what defines a guest versus a tenant? A tenant pays rent and has a lease agreement. A guest is not on the lease. So, if you want to call the cops, if you're renting a room, you want to call the cops and get a guest removed, you can do that according to 33-1378 at any point in time, no reason. That's the new law, right? So there used to be a time frame. There is no time frame for a guest to become a tenant. Okay. Real territory conduct prohibited. Okay. Residential rental property definition. Appointment of temporary receiver, term, duties, accounting, inspections, slum property appeal, licensed property management company, training program, registration with one call notification center. Chapter 12 deals with residential rental inspection programs, the definition, individual property inspections, material effect on health and safety of occupants, adoption of citywide residential rental property lease licensing, registration or inspection program requirements, inspection fees, penalties. Arizona Revised Statute Title 33 deals with property. Chapter 3, landlord and tenant. Discrimination by landlord or lessor against tenant with children prohibited, classification exemptions, termination of tenancies, landlord's lien for rent, limitations, Title 12, courts and civil proceedings, forcible entry and detainer, acts which constitute forcible entry or detainer, definition of forcible detainer, substitution of parties, additional definition of forcible detainer, immateriality of time possession obtained by tenant, demand for jury, trial procedure, trial and issue, judgment, writ of restitution, limitation on issuance, criminal violation notice, complaint and answer, service and return notice and pleading requirements, appeal to superior court, notice, bond, stay of proceedings on judgment, record on appeal, trial and judgment on appeal, writ of restitution, appeal to Supreme Court, stay and bond, proceedings, no bar to certain actions. Application for occupancy. This is on Transaction Desk. It was developed by the Arizona Association of Realtors in the AAR forms. So for the application for occupancy, line 1, you're going to put the address of the rental property you're applying for. Put the applicant personal information. Line 2, put the name. Line 3, mark if they're single, married, or separated, or divorced. Line 4, put the email address, security number, driver's license, desired date of occupancy. How'd you hear about us? Sign. Line 9, put did they see a sign? Was it on a website? Was it on an ad? Was it on a referral? Employment and bank references. Put down is their current employer, the address, telephone, department. If you have been with your current employer less than 1 year, please complete the following. Who was your previous employer? What was the address? What was the telephone? Please provide a valid, enlarged copy of your current driver's license or government-issued photo ID and your 2 most recent pay stubs or proof of income. Put the bank, telephone, account number, residence history, current rent, current address, city, landlord. If owned, please provide mortgage company name and address. Okay, page 2 of 3. On the application for occupancy, add your personal references, name, address, your relationship with that person, telephone, dependents, additional occupants, line 42, number of people who will occupy the residence, list occupants with and their birth dates. Credit and criminal background check will be run on each person 18 and over. So you're going to put the name, the relationship, the date of birth, person to notify in case of emergency, and that you authorized to enter and take possession of your personal property in the event of death pursuant to ARS statute 33-1314. If you have any pets or service animals, will you have pets? Mark yes or no. Assistive and service animals are not considered pets. Okay, I repeat, um, assistive and service animals are not considered pets. Line 55, description of pets. So put what breed they are, what the age, what is the gender, what's the weight. Will you have an assistive or service animal? You put yes or no. Put down your vehicle information, the total number of vehicles, make, model, year, color, license plate number. Okay. Then goes for the credit and background history. Have you ever answer all questions for yourself and for anyone who will occupy this residence? So, have you ever been evicted? Put yes or no. Has a notice of eviction ever been filed against you? Yes or no. If so, when? Have you ever declared bankruptcy? Yes or no. Have you had two or more late rental payments in the past year? Yes or no. Have you ever willfully or intentionally refused to pay rent when due? Do you currently owe any monies to an apartment community or landlord? Do you use illegal drugs? Have you ever engaged in the distribution or sale of illegal drugs? Have you ever been convicted, arrested, or charged with any crime? Please give details, explanation, dates, and names for any questions answered. Yes, above. Do you have any outstanding warrants or anticipate any warrants for your arrest? Yes or no? Application for occupancy, February 2013. Copyright 2013. Arizona Association of Realtors. All rights reserved. All right, last page, 3 of 3, additional information. This you're gonna add. Have you or anyone in your household had, or do you presently have bed bugs or other pest issues? Put yes or no, and then if yes, please explain. Please give any information that might help evaluate this application. Deposit to hold agreement. In consideration and management holding this prop In consideration of management holding this property for me, I agree to pay earnest money holding deposit of a minimum of blank and a non-refundable application fee of blank per person over 18 in certified funds only. Additional fees. So here, this part is if you want to put earnest money or deposit down. I used to rent rooms. My rooms were like $600 a room. So if somebody wanted to put a deposit down, it'd be $600. Okay. Additional fees will apply for non-U.S. residents and will vary according to current rates. If you are a non-U.S. resident, please call for correct application fee amount before applying. Non-resident application fee blank. The earnest holding deposit is refundable. If my application is not approved, 14-day delay required for bank clearance of check. If my application is approved, the earnest holding deposit is credited to the required move-in costs. If applicant should withdraw this application within 7 days after written notification of acceptance, a minimum of this much money of the earnest will be retained in addition to the non-refundable application fee. If after 7 days of notification of acceptance, applicant withdraws or fails to execute lease agreement, all earnest holding deposit monies will be forfeited. Under no conditions will application fee be refunded. Total deposit fees submitted with application is this much money. So when you're applying for housing, typically property managers, they're not going to give you your money back, right? It says right here, line 96. You put down how much money they're going to put down for a deposit. Um, if you decide not to take the apartment or the property, then they just keep your deposit. Line 98, I hereby authorize and instruct owner, broker, property manager to investigate the information supplied by me and to conduct inquiries concerning my income, credit, and character for the purpose of verifying and qualifying for this rental and any renewals thereof. So again, they're checking your income, they're checking your credit, they're checking how you are as a person, your personality, your character, right? So when you do fill out an application of occupancy, you want to make sure you answer honestly. Because if you found that you're lying, then they're probably not going to rent to you. Okay, so let's go down. Uh, Applicant acknowledges that owner, broker, property manager may not be able to complete a comprehensive evaluation of this information prior to move-in. Owner, broker, property manager reserves the right to verify application information after move-in and may convert the proposed lease agreement to a month-to-month term or declare the lease irreparable breach and seek immediate eviction. If false or misleading information is contained in this application, applicant agrees to the terms of this deposit to hold agreement. This application is preliminary only and does not obligate the owner or owner's representatives to execute a lease or deliver possession of the proposed property. Owner or broker or property manager comply with federal, state, and local fair housing laws and regulations. Unless otherwise agreed, I understand that the brokerage, the broker, its agents, and employees are agents of and represent the owner in leasing this property. So have your applicant's initial here. By signing below, I acknowledge and accept the qualifying criteria and policies of the owner, broker, property manager by which my application will be approved. This application must be signed by the applicant, so have your applicant sign there. And falsifying information on this application is grounds for rejection. So if we call and we understand that someone lied, we could just flat out reject you and then keep all your money.